yesterday's case can be listed tomorrow, otherwise it will be.
I have already ordered.
For if the contract is awarded to somebody, then my lord,
Yes,
it is
like, yeah.
it will be infractious.
MS Fakya,
Yes, my lord.
recalling my earlier order, I have already ordered to list it tomorrow.
Tomorrow. Much obliged, my lord.
In front of you, I have ordered.
Yes.
Meet with your
Tomorrow.
lordship.
8 of December.
Friday দিল ফ্রাইডে দিছিল দেখুন কালি দিছিল দেখুন 8-9 only না না কালি তো করলো আকৌ ফ্রাইডে করলো না হ্যাঁ নহয় পিছত আকৌ চেঞ্জ কৰিছে নেকি হ্যাঁ অর্ডার সাহেব পঠালে নেকি হ্যাঁ আহিলে নেকি ফাইলটো হ্যাঁ ফাইল হোক
I've gone from various clauses. I will satisfy your lordship. Obliged.
8 days, Lord.
কালি
Meet with your lordship. I'm paying for listing of a reputation for motion lordship. My BPCL fuel station, that the agreement was cancelled and the order was issued for taking away all the equipments, lordship. So can it be tomorrow, lordship? There is urgency. The order has been issued to take away all the equipments of my running fuel station, lordship.
ওকে
Obliged,
Please, your lordship, item number 4, we have filed affidavit in reply yesterday, your lordship. It may kindly be called for.
May I please, lordship. Lordship, I beg to mention for listing for admission. The matter pertains to confirmation of Patka.
পাত্তা ম্যান ফাইল
May I please, my lord, item number 17, my lord, last hearing, my lord. In this case, my lord, for petitioner side, my lord, senior counsel PK
I am for
Goswami
a
appearing, my lord, and for respondent number BC Das appearing, my lord, but BC Das, my lord, is suffering from eye flu, my lord.
Hmm?
Eye flu, my lord. So
Eye?
Eye flu. Eye disease, my lord.
ওকে
My lord.
সিরিয়াস
Yes, my lord.
ওকে
So, my lord, can it be fixed, my lord? On 12, my lord.
17 meter. We are
Yes,
fixing 12, 2013, 14, 12.
17 meter, but stay.
Let it be after 2 weeks.
Lordship.
Mr. Sohan, yes, Sohan,
For 3, my lord.
learned counsel for the respond number 3
Yes.
has sought adjournment on the ground that leading counsel, Mr. BC Das,
No.
has is suffering from suffering from eye problem.
May I please, lordship. Lordship, I'm appearing
One.
for a petitioner in this matter. There
Mr.
is an interim order. L. Sankam, lordship.
L. Santham,
Yes, lordship.
learned counsel who is preparing for a petition, has no objection to the said prayer. Post of the prayer made by Mr. Chauhan is allowed, list the case after 2 weeks. The interim order silo, interim order
Much obliged.
shall continue. Till the next past 5 minutes.
Meet with your lordship. I'm praying for listing of a matter on 11th or 12th, my lord. It's a tender matter, my lord. There's a stay operating. 12th, my lord, subject.
Why 12,
Lord.
11 or 13?
May I please, your lordship, I beg to mention item number 3. Lordship, in this matter, petitioner has filed affidavit in reply yesterday, lordship. Lordship, I need some time to get instruction. I have taken consent from the petitioner, lordship.
I'm praying for the petitioner, lordship.
Okay, Mr. T. Deuri, learned counsel for the petition is present. MS RR Kokoti, learned counsel for the respond number 1 to 3 has submitted that the affidavit in reply filed by the petitioner has been received yesterday, and she one week's time, 1 week or 2 weeks,
2 weeks.
2 weeks time, are required to go through the same. Post of prayer made by so and so is allowed, list the case after 2 weeks only, 2 weeks later.
May I please, your lordship. Lordship, I beg for,
Interim order,
No.
okay, after 2 weeks.
lordship, I beg for listing of a repetition, lordship, last posted on 15/2, lordship, 23. So,
Subject matter,
lordship, non-payment of contractual
Thai Republic.
obligations.
May I please, lord.
Well, later matter come for admission on 8-9 million matter related to settlement of market million. Even after 2.5 months, it has not been listed, although notice has been served.
Maybe in the week starting from 11th,
Then,
any day,
yes. 10, 12,
maybe 15.
15.
May I please your lordship. Lordship, I beg to mention for listing of a matter in the admission column, my lord. Matter pertains to non-payment of contractual dues, my lord.
15.
Obliged, my lord.
Daily list for admission item number 1 and 2.
Wait, please, your lordship. Lordship, in item number 2, the state has filed an affidavit on 23rd of this month. I need some time to file a rejoinder to it, my lordship.
Mr. S. Vishwakarma, learned counsel for the petitioner, has prayed for and is granted
2 weeks, my lordship.
2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents in
In WPC 6026 of 2020.
Mr. Das, you appear for private respondent.
Private, madam.
Six.
Yes, number 6, my lord. 6 and 7.
Mr. M. Chetia,
In
learned
WPC
judicial
number,
government advocate Assam for the state respondents, and Mr. N.C. Das, learned senior counsel assisted by M.S.
Mbora.
M. Bora, learned counsel for the respondent society. Are present.
no, in item number 1, my
Can
lord,
it be fixed,
item number 6, my lord.
Respondent society,
Obliged.
respondent society are present. The prayer in the region cited, when the prayer made by Mr. Vishwakarma is allowed, these the cases after 2 weeks on a date.
Can a date be fixed, my lordship?
Good, it's so far as this file of commerce.
28-9.
Obliged, my lordship.
Okay, limit 9 to 9. Go to Matak, bro.
Yesterday, an affidavit has been filed.
Affidavit?
Affidavit reply has been filed.
You have filed affidavit in opposition or not?
Reply has come.
reply.
Reply
It
has
is not there.
It's not on record. I have
No,
called,
affidavit in opposition is also not on record.
come. Opposition, long back it has been filed.
Nothing is there.
Filed on.
Lordship, there are a number of discrepancies which I have pointed out.
Well, in the meantime, I have to get the instruction.
Huh?
Because he says he will come in the 4th place because he will, the petitioner will get more marks. I have to get back to the department and get the calculation done.
Then don't proceed in the
Don't
meantime.
proceed.
No, panel has been there. It's a panel, my lord. It's
They
a
will
panel, my
not
lord.
award the work.
Not it. Panel of 6 has been selected. And if he succeeds, then he will get into the total 6 panel.
Right. What about your affidavit? I don't know about your stand in the affidavit.
Affidavit, my lord, we have given the chart, the mark obtained, everything has been given. He is in the, his serial number is given, he is given the 10th position.
10.
10 position. So only 6 will be selected. Now the calculation has been given in the affidavit opposition, affidavit reply that the petitioner will come in 4th position. So
Because
I have to
the
get
position
back
is not
to
correct.
the department.
Now what to do?
According to me,
Lots will
the-
place, fix it on 7. I will get back all the I will have to put that if you know to the department, they will I'll get the instruction lots of
Yes,
the calculation.
as long as they don't
Petitioner
allot
made a
tenders.
separate calculation of his own chart.
First 3, it's all right. Next 3, they don't have. Because
So
And
then,
the persons who have been selected 6 persons, and they have not been made party. That is
No,
one of
that
the,
that is a serious defect, MS.
no, Lordship, I have filed a second,
Ajay.
I have filed after Lordship, what
Because-
has happened?
at least
I
3 person will be
I
out.
cannot file it on presumptions. Because till then, I didn't know where I stood. It could have been I may be 10th, maybe I was 12th. I don't know what. So I cannot stall this. So I did not file that.
I
I
think
have-
better after exchange of pleading, if the new situation has emerged,
Yes, I have,
then you
filed-
better file your appropriate pleading.
Lordship, I have filed a fresh requisition today, implementing them and explaining why I didn't file. So let that also be tagged together on the 7th.
7.
7th,
not
I have
seen the
filed the
copy.
appropriate petition.
If your position gets upgraded, Definitely court will pass appropriate
Yes.
order.
Absolutely.
If
Lots
the,
And let
from the
seven
materials on
pointer-
record, it emerges that petitioner is likely to be upgraded.
Lots.
Then definitely so better. I think you exercise restraint.
And Lordship,
You better exercise restraint on your part.
let them produce.
Otherwise,
No, it's a continuous process. If he gets interest to the in of 6, we will allow him.
okay.
Because 30,000 now, another 2 lakhs will come up in the future.
I heard MS M. Hajurika, and Senior Counsel assisted by MS K. Lawyer, Learned Counsel for the petitioner, and Mr. S. Bora, Learned Standing Counsel, Department of Housing and Urban Affairs for both the respondents. Full stop. The Mr. Bora, Learned Standing Counsel, so and so, has submitted that an affidavit in opposition on behalf of the respondents has been filed on
25/8, my lord.
25/8/2023. MS Hajurika has submitted that an affidavit in reply to the said affidavit in opposition has also been filed today or tomorrow? Today,
I
Yesterday.
filed it
30.
yesterday.
tomorrow, or yesterday, affidavit. Full stop. MS Hajurika has further submitted that the petitioner has prepared another writ petition.
Yes, I filed it today.
Okay, which is yet to be numbered.
Yes.
Full stop. The Learned Counsel for the parties have as the affidavit in opposition filed by the respondents and the affidavit in reply filed by the petitioner are not on record. Let the case be listed on next. What is the date?
7.
7/9.
On the
7.
Along with the motion.
7/9/2000.
7th is a Thursday, my lord. If
Yes, that's okay.
7.
Seven.
7.
7 is a Thursday.
Then
It will be on
8.
8.
Because 7, I remember 2006, 7, 8, 9, 10 petitions are listed.
And Lordship, along with the fresh writ petition, Lordship. I'll give the serial number.
Get the serial number, make a mention through MS Lawyer tomorrow 10:30. I'll permit.
Okay, Lordship, obliged.
List the case, no?
8/9.
8, 9.
For orders, item numbers 5 to 10.
Yes, what to do?
Yes, Lordship.
Mr. Nayak, it is up to you.
Lordship directed me to obtain instruction as regard whether any list has been prepared or not pursuant to temporary judgment, Lordship. As I have been instructed, Lordship, it is it is already there, but they are completing the list, Lordship.
I think better for you,
Yes, Lordship.
so that whenever any contempt petition comes,
Lordship.
you can say that from the list, your position is this. Whenever your turn comes, your money will be released.
In fact, that is favorable to us, Lordship.
Yes, it will be favorable. That is why that your position is 50.
Yes, Lordship.
So let the first 49 above you get the money. Thereafter, you will get the money.
Yes, Lordship.
I think it is better,
We have instructed, Lordship. It is
and we can
already-
also close the contempt petition easily, giving the liberty whenever, suppose 55 position is receives the money instead of 50. He can prefer the writ petition again,
Lordship.
violation of clause 14, article 14. But I think if you streamline,
Lordship.
if the claim is registered serially, I think it will be better for you.
Yes, Lordship. We realize that, Lordship, but the authorities, because I know some,
You make them understand.
Lordship, on next. day-
Otherwise, everybody has to file affidavit in reply, affidavit in opposition. Yes, paucity of fund.
On next date, Lordship, I will place one place, Lordship.
Yes, MS.
Lordship.
Lordship, in the meantime, they have filed one IA for impeachment.
11, we have filed an IA.
Okay, let the first thing
Present
be there. 5 to
11, I think.
11. 5 to 10.
Yes,
10, Lordship, sorry.
In 11, IA is
IA is filed, Lordship.
MS
And us.
and us, Learned Counsel for the petitions is present. Mr. P. Nayak, Learned Counsel for the respondents, has submitted that he has received instructions to the effect that the respondent authorities are trying to streamline the claims of the contractors chronologically by maintaining a register in the light of the directions in terms. I think Jotin Pathak, actually Jotin Pathak.
No.
It was in Jotin Pathak,
Yes, Lord Chief.
right? এটাতে কাউন্সিল আছে WBC নাম্বাৰটো চাই ল'ব লাগিব right of direction made by this court in WBC number so and so within bracket Jotin Pathak versus State of Assam it and Tamsir Ali and others State of Assam reported in 2004 ZLT 1 FP. So stuff he has prayed for listing of the cases after 3 weeks.
For Lordship and kindly make it.
4 weeks.
We'll place it definitely.
To file an additional affidavit in you have filed affidavit, right?
Affidavit we have tried.
An additional a consolidated additional affidavit in opposition in this matter. So stop. The prayer made by Mr. Nayak is allowed to list the cases after 4 weeks. Right.
4 weeks is too long.
No, the fund is not there. And that is not willful disobedience.
Yes, Lordship.
Right? If the fund is not there, that does not amount to willful disobedience. Prima facie. But once list is prepared,
Yes, Lordship.
then money is disbursed to a contractor who is below you, then it is willful disobedience.
Yes, Lord. Yes, it should be there. Lord.
Yes. Next to the
Item number 11, Lordship.
MS TFL Liquido and Mr. P. Nayak, Learned Counsel for the respondent.
Respondent is not
Response.
there.
Respondent number 1. You appear for Anurag Goel,
Yes.
right, Mr. Nayak?
Yes, Anurag Goel, I'm appealing.
Arun Kumar Goswami? No.
Lordship, I'm representing him
For
also.
both the respondents. Full stop. The instant interlocutory application has been preferred by the petitioner, who is the petitioner, who is also the petitioner in connected contempt case number so and so, comma, seeking impleadment of Shri Akashdeep, comma, IS, comma, Principal Secretary, comma, PTC, Kokrajhar, Assam District, Kokrajhar, BTR, PIN 783-307. You have not mentioned, I am mentioning.
370, Lordship. 783-370.
You have not mentioned in your application, mention.
Lordship, we have mentioned
Okay.
in page number 20.
Following. As a party respondent in a connected contempt case number so and so on the ground that the earlier incumbent Principal Secretary Sri Anurag Kumar has in the meantime been transferred from the state office of the Principal Secretary BTC. I have gone through the statements and environments in this interlocutory application. As the present incumbent, as the implement of the present incumbent in the office of the Principal Secretary BTC is necessary for the purpose of deciding the connected contempt so and so, the instant interlocutory application is allowed the office to correct the cause title in a connected so and so. And to stop the will issue notice
Yes, notice.
in the mean. In view of the order passed today in ISC numbers so and so, comma, the notice is issued. Notice is issued to the newly impeded party respondent number 3, making the notice returnable in 4 weeks. The petitioner shall take steps for service of notice upon the party newly implemented party response number 3 by registered post with AD within 3 voting days. This is the case of the protest.
Briefly obliged.
Lordship.
For hearing item numbers 12 and 13.
Yes, Lordship. The last occasion, this honorable court has directed me to take instruction whether there is any concept of vitiation or anything while floating the tender on behalf of NF Railway. I made an instruction from the department, an instruction has given from my department. This is just circular where it has been clearly mentioned about the vitiation of the contract.
Now, have you made this circular part of the contract?
Yes, it is there. And also there is a format of the affidavit where they, if any kind of forgery of the documents.
1 minute.
Lordship.
This is a circular.
Lordship.
And we are dealing with contract of which year?
Lordship, this is a
We are dealing with, I'm
2006,
2006.
27.
You are relying upon a 2018 circular.
Otherwise, it is same year, Lordship, although it.
No, I am asking you whether we are dealing with a contract of 2006, right?
Lordship.
And we are dealing with a repetition of 2012.
Sure.
And you are showing me a circular of 2018,
Lordship.
right? How can it be binding? A contract, it is only contract, non-statutory contract, executed between the parties. A concept which has come later on. Though a mention is there, vitiation, but that is not explained
Lordship.
in the contract. How could you know? If you go by the dictionary meaning, you do not understand. Tell me, Mr. Gogoi, can you understand dictionary meaning of vitiation?
There is no specific in this part.
So, if you may want to make the contractor understand that what is vitiation, you have to explain it or you have to provide the definition in the contract. And also make a mention about that this
Tender number.
whatever, this policy, this is policy. This policy is part and parcel of the contract agreement. I have seen. It is not that I have seen now your subsequent contract agreements,
Yes.
right? That day I have, while dealing with another matter, but the contract agreement was part of the repetition. While going through the pages, I suddenly saw that vitiation is there
Lordship.
and there is a mention of this particular circular that it will be treated as part and parcel of the contract.
Contract
Then you can bind the contractor. Yes, it is there
in the original.
in the contract agreement, part this policy circular.
Lordship.
But here I don't think it is there.
The
This
last format is the affidavit is there. We make a formulation of the affidavit. That is a model.
model, but it will be applicable. That affidavit has come along with the circular,
Lordship.
is it not?
Lordship.
This circular is of 2018. So affidavit, the format of the affidavit is born in 2018.
Lordship.
It was not born in 2006. Born.
I can't say.
Tell me. It
But-
is you who has to explain.
But my Lordship, my part in this case.
Let me go through it. Do you have a copy with you?
No.
These are single copy.
Yes, sir, I can.
See 3.2
Lordship.
of this policy. In all works, tender documents, the following para may be added in the section describing the qualification and eligibility criteria. Now you have brought the form of affidavit, standard form of affidavit that contractor has to sign. So it cannot be born before.
Lordship. So the contractor undertake, your lordship,
But
it is a case of, my case is a forgery case. It is a total go in a different direction. My
I
affidavit,
have heard the word forgery
yes,
for the first time in this case.
yes, it is there, your lordship. For, if lordship permit me for one moment, your lordship. For, there is a need for the forest royalty clearance certificate that ought to be procured from the forest office.
Question raised here is that the amount sought to be deducted by you raising the concept of vitiation is correct or not correct.
Lordship.
And forgery cannot be proved in a writ petition.
But
Maybe you can raise all these issues. Have you filed any
yes,
FIR?
if lordship permit me to go our affidavit in this case, paragraph 8 categorically mention your lordship.
No, WBC, we are not into WBC 266. We are into WBC 6103.
That is.
You are a counsel.
That is Mr. BK Das is my standing counsel. That is the part where lordship has asked me the vitiation contract along with me also.
We are not dealing with as on date
I am here, sir.
266. We are dealing with 6103. We have not heard any single submission on 266.
I am confined on my part and
That is
Yes,
a different
what is
issue
about-
that is specific to that case.
to assist.
Here there is no question of forgery or so and so. The contractor executed the work, then measurement was done.
Final measurement was.
Final measurement, original contract value was 18 crore.
Lords.
Final measurement was done, and thereafter it came to 12 crore. Petitioner is agreeable to that.
Lords.
Then you impose that vitiation clause suddenly and try to deduct more money.
Lords.
Am I clear? Where is Mr. BK Das?
Coming, man, he's
Huh?
coming, I guess.
Yes. You are ready?
I think my senior is appearing before other point.
Yes, next case, Mr. Roy. Ready? Okay, after next one, we'll take up.
Lords.
এইখন থৈ দিব এইখনো থৈ দিব এইকেইটা পেপাৰত থৈ দিব item number 14.
Item 14.
May please your lordship. My lord, this is an application against the award passed by Labour Court. And at the very outset, my lord, my submission is, my lord, under 226, your lordship enjoys wide power, my lord. Ample power, your lordship, is an extraordinary jurisdiction, my lord.
No, I am asking you, I asked a question.
Yes.
Whether the decision taken by the Labour Court to discuss only the evidence laid before it and to pass the order only on that basis is the correct proposition of law.
It is not, my lord.
Not.
My lord, law holding the field is that, my lord, when there is an domestic inquiry, my lord, the Labour Court first have to examine the domestic inquiry. If domestic inquiry is bad, then labor court can go.
I
to
think
the
that
merit of-
one avenue
that
is all,
one-
that avenue is available to
yes.
you once we remand back the case to argue the matter. Otherwise, law is correct.
My lord, law is correct, but my lord, lordship may see the findings, my lord. The
No
fi-
finding, but
No,
he has gone in a different way.
No, it is mentioned, my lord. I'm just, that's what the show. It is also pleaded that the domestic inquiry is also not initiated in accordance with the law applying the principles of natural.
Where is the discuss recording of region?
No, that is what the finding, my lord. Thereafter, this court examined the management, then they.
That's, he has to record the region. Why?
Yes,
So many witnesses were recorded.
yes.
Is it not? Domestic inquiry.
Say, five.
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 Charges were framed. Somewhere I have seen in the High Court judgment.
Ah.
High Court judgment. Earlier remanding back, let us see the High Court judgment somewhere. That day we read.
Yes. Mr.
Initially, it is 72 Supreme Court.
70 to 10, it goes on.
Oh, yes,
It
Yes.
continues. I have seen
Yes.
one 2021 judgment.
yes.
That position is still on.
It's
Yes,
still on.
yes,
Still on.
yes,
That
yes,
is
yes, yes,
no dispute to that.
I cannot travel beyond that.
Yes. Then lordship will remand. back the-
Apparent on the face of the record.
Lordship will
I'll
remand
remand
the
the
matter and
A record to
And in various cases, my lord, Dudbuk Singh cases has been discussed, my lord. And now the law, as interpreted by the Honorable Apex Court, my lord. It is at a very earliest management should file an application, my lord, for if they want to go on merit, my lord. If they want to examine the witnesses, my lord, and then along with my lord, at the very outset, my lord, they should make that prayer, my lord.
Now let us see the LCR. It is also incumbent on the presiding officer also. They, because I think that which one, 1972 that they I referred.
Yes, my lord.
I think that propositions are clearly there.
Your lordship may.
Even if the
that is Delhi Court General Mills versus Ludbuk Singh.
that day after
After that,
after hearing was concluded, another counsel gave me a list of judgments. Who was hearing me? Both of you. He gave me a list of judgment and I have gone through it. I saw that the principal
Yes.
is holding the field till date.
yes, that is, the law is correct.
And my lord, that Dudbuk Singh.
Let
case,
me
my
go through
lord,
the orders.
Yes.
Let us, that will make the position clear.
Yes.
What he did after receipt of the notification,
Yeah.
he issued notice to both the parties and to file written statement.
Thereafter, the matter went on like that. Then suddenly,
Let me see which is the order. Record, put up, seen the petition, no WS.
I didn't find any specific order, my lord, but suddenly one state
Request
manager
counsel
witness
for
examined.
petition paying to file about, without management files, we can take it. Management file for time. With the previous order, MS Bhattacharya, that previous order which was set aside, is it part of the record? Part of the repetition?
No, sorry.
Because award was passed on 19/3/2002.
Yes.
That award is there on the record.
December, 6 December 2000.
19/3/2004.
6 December 2000. Okay, students. Further evidence. For the 6 December. MW1. MW1. MW2. MW3. MW4. WW1. WW2. So 5 on the management side,
Yes.
2 from the workman side.
Yes, only two.
Those were
Two were-
recorded by the labor court.
Yes.
Yes.
Labor court, right. And 6 in the domestic inquiry.
When the matter was remanded, he said domestic inquiry, 1 line. Which paragraph?
That is, my lord, award. I mean, page 3 of the internal page 3.
Internal page 3. Yes,
In the middle portion, my lord, it is also pleaded that domestic inquiry.
which one? Is also not initiated. That is in the plea taken in the written statement by the workman.
Workman.
Then what did he did?
But he then examined the management witnesses.
There he went wrong. So he started discussing the deposition of the witnesses recorded in the labor
Labor.
without discussing the,
Yes, domestic inquiry. It was the
because if I have understood correctly, principle is that if the domestic inquiry is correct, then there is no authority
question of
on his
evidence.
part to
Examine the.
to discuss and appreciate the
Yes.
evidence.
But
I
my
think-
lord, the workman has pleaded that it is a violation of natural justice. As per.
But you will discuss.
Yeah.
That I will not discuss.
No, I'm saying that labor code, on the strength of that workman saying that it's a violation of natural justice, the examine and all that. That's why he took the evidence now.
They pleaded,
But without saying much about,
he has to,
he has to, but he's not done that.
all the judgments,
Yes.
all the judgments have said, he has to first discuss and find out whether this domestic inquiry was done as per the
As per the
principles of
principles
natural
of-
justice. You notice all this. After that, if he finds that that was bad, then he can discuss the
Yeah.
evidence laid before him. I think that is the law.
That's correct.
Yes, in the paragraph 61 of this.
In fact, most of the disciplinary proceedings, 2005-6, the judgments are there, lots of judgments.
No, I have seen judgment. Up to 2021 judgment I have seen,
Yes,
this principle is followed.
yes.
And if this is noticed, then High Court, even if after lapse of time,
मारेगा पकड़ के.
this is to be ordered. MS Bhattacharya and Mr. Roy, please correct me if I go wrong. Factual part.
की लगा? हाँ?
Itu nahi.
ये लगा. दादा.
The last one is 2022-3 SCC 190. Where all this, not Delhi, but it discussed Firestone tire. Then it discussed Karnataka SRTC versus Lakshmi Devamma. It is 2001-5 SCC 433 Constitution Bench. Constitution Bench. Let me record the facts.
Yes.
Please take your. The writ petition is preferred by the Secretary, Assam Chah Mazdur Karmachari
কর্মচারী সংঘ
Sangha,
অসম চাহ কৰ্মচাৰী সংঘ
Ahom Sah
আসাম চাহ কৰ্মচাৰী সংঘ
Karmachari Sangha, a registered trade union of tea garden workmen within brackets Karmachari registered under the Trade Union Act 1926, on behalf of the workmen of Doyang Tea Estate. Full stop. In this writ petition, an award, A capital, dated 6/11/2012, passed by the learned presiding officer, Labor Court, Dibrugarh, in reference case number 20 of 1999 has been essayed. By the award dated so and so. Report eligible and trial court for short. The learned trial court in the award. The learned trial court has held that there is nothing to hold that the delinquent employees did not get any opportunity to defend their cases. And has proceeded to hold that the management was justified in dismissing the two workmen after holding the domestic inquiry. And as such, there is no justification for directing reinstatement of the said two delinquent employees. My inquiry report is here,
Yes,
the domestic inquiry,
yes, it's there, my.
exhibit 16.
Exhibit 14, my lord.
Exhibit 16.
16, no? Inquiry report.
All the evidence are there.
Yes, all the evidence.
Let me structure. It is difficult to structure 1998. How to proceed. There are two workmen,
Two, my lord.
two workmen,
Two workmen, one is the driver, my lord,
EIZs, namely
Mubarak Ali
one,
and Binu.
Sri Benudhar Tasa, and two, Sri Mubarak Ali, were employed as Fort Tea House and driver respectively at the tea estate known as Messrs. Doyang Tea Estate, situated in district Golaghat. The genesis of the present list is an incident which occurred on 5/10/1998,
610.
6/10/1998. Full stop. An allegation was made from the management side of Messrs. Doyang Tea Estate on the basis of complaints received by it, right? Am I correct?
Yes.
To the effect that there was removal of one bag of tea, comma, weighing about 30 kgs from the factory premises of the tea estate in an unauthorized manner. Full stop. It was alleged that the workmen carried the said bag in a vehicle bearing number AS-05/4661, comma, belonging to the tea estate, comma, along with other bags of from the factory premises to Golaghat. Full stop. Though other bags were delivered at the premises of the transport carriers for further transportation, comma, the bag in question, comma, weighing 30 kg, weighing about 30 kgs, was allegedly sold to some other person. Full stop. It was alleged that the two workmen were involved in the state were involved in such unauthorized removal of the bag of tea weighing about 30 kgs and selling it off to a third party for the purpose of misappropriating the sale proceeds thereof. Full stop. Finding the allegation serious, the management suspended both of them on 17/10/1998, pending drawal of departmental domestic inquiry and final orders. Full stop. A charge sheet. The management had alleged that a projection was made from the management side that Sri Benudhar Tasa was not a workman within the meaning of section 2 within bracket S of the Industrial Disputes Act, as he drew a salary exceeding rupees 1,600 per month, and his role was supervisory in nature. Full stop. The management issued a charge sheet against both of them seeking their explanations within a date specified in the charge sheets. Full stop. It appears that the original charge sheet came to be amended on a later date, and the amended charge sheets were duly served upon the two persons. Full stop. Replies were received from the two persons sorry. The two persons. On receipt of the original charge sheet, the two persons submitted their replies, appear to have submitted their replies. Full stop. On receipt of the amended charge sheet, Sri Vasudev Tasa submitted reply on 7/12/1998, stating that his earlier explanation should be treated as a reply. Earlier explanation made in reply to the original charge sheet, should be treated as the explanation in respect of the amended charge sheet. Full stop. A domestic inquiry, an inquiry officer was appointed, and the process of domestic inquiry was initiated. Full stop. The two persons, the delinquent employees took participation in the domestic inquiry. Full stop. In the course of domestic inquiry, comma, the management side examined 6 witnesses in respect of the charges level against the two delinquent employees. And full stop. It is the management witness. All were cross-examined. And all those management witnesses were cross-examined by the delinquent employees. Full stop. After closure of the evidence from the management side, comma, the two delinquent employees made their respective statements in the inquiry. Full stop. As per the inquiry officer, comma, both of them declined to produce any witness in their defense. Full stop. After conclusion of the domestic inquiry, comma, the inquiry officer submitted a domestic inquiry report dated 30/12/1998. Wherein the inquiry officer reached a finding that an additional bag of tea weighing in between 20 kg to 30 kgs was taken out illicitly from the factory premises of Messrs. Boyang Tea Estate on 5/10.
Yes.
I don't know. On the date of the incident. Full stop. A finding was reached to the effect that the employee, comma, Venudhar Mose, who was in charge of the dispatch, DESPATCH, that day, comma, was primarily responsible for the removal. Full stop. It was held that the other employee, Mubarak Ali, sold the said tea tag at Golaghat for personal gain of himself and that of Venudhar Tasa, who joined hands in the entire process. Full stop. The inquiry officer had held that both the employees, one Venudhar Tosa and two Mohammad Mubarak Ali, were guilty of misconduct for clause 10 within bracket small a within bracket 2 of the standing orders in force in the tea estate. Full stop. On receipt of the domestic inquiry report dated 30/12/1998, the management, on the basis of the findings recorded in the domestic inquiry report, decided to dismiss both of them from their services. Full stop. Para. Report. Being aggrieved by the dismissal of the two employees, the trade union, Messrs. Ahom Sah Kormosari Hongho, Golaghat Circle, raised an industrial dispute through its secretary, raised an industrial dispute in consideration of the same, the government of Assam in Labor and Welfare Department referred it to the Labor Code. By the notification number ZLR point 239/99/15 dated 26/11/1999. Full stop. Yeah, right, page 21. The contents of the notification dated 16/11/1999 raises under. No? It will- Para. On receipt of the notification dated 26/11/1999, comma, the Learned Labor Code, comma, Dibrugarh issued notices to the parties calling upon, notices to the parties asking them to file their respective written statements along with all other documents on which they intended to rely, comma, by an order dated 15/12/1998. Full stop. On receipt of notices, comma, both the parties, comma, that is the management side and the workman side, entered their appearance, made their appearances before the Learned Labor Court. Full stop. While the workman side through the union filed their written statement on 29/6/2000, comma, the management side filed its written statement on 5/6/2001. Itur agot, a notification, notification agot. On receipt of the notification, I can push the Learned Labor Code registered the same as reference case number 20 of 1999, right? Good stop. From the workman side, comma, it was contended that no proper domestic inquiry was held and the workmen were denied the opportunity of proper opportunity of hearing. Full stop. And as such, comma, the domestic inquiry was not fair. Full stop. Allegations were made to the effect that the inquiry officer was biased and his findings were perverse. Full stop. Refuting the contentions, the management side in their written statement had contended that the domestic inquiry was conducted strictly in compliance with the principles of natural justice, and the inquiry was fair and reasonable. To stop. It was contended that both the workmen were given full opportunities to defend themselves in the inquiry. It was after proper appreciation of the evidence laid in the course of domestic inquiry, comma, the inquiry officer found both the workmen guilty of misconduct and arrived at the finding at the conclusion that the charges leveled against them were duly proved. Para. After submission of the written statements by both the sides, comma, the labor court had proceeded to record depositions of the witnesses from the management side. On different dates. To stop. From the management side, 5 witnesses, namely MW1, that's Madhav Borua, within bracket, examined on 6/12/2000. And examine and cross-examine on 6/12/2000 and 10/8/2001, bracket closed. MW2, Orup Kumar, examined and cross-examined on 13/9/2001. MW3, Hollo, HOLLO, Bhakti, BAKTI, Bhakti, within bracket, examine and cross-examine on 13/09/2001. MW4, Tintus, TINTUSH, Mura, MURA, examined and cross-examined on 11/12/2001. And MW5, Suren Mura, examined and cross-examined on 11/12/2007. Sorry, 2001. Full stop. From the learned labor court also recorded depositions of two witnesses from the workman side as WW1 within bracket WW1, that's Muhammad MD, Mubarak Ali within bracket, examined and cross-examined on 9/1/2002, and WW2 within bracket, that's Benudhar Rasa within bracket, examined and cross-examined on 9/1/2002. What is the judgment then? First judgment. First judgment.
9/3,
Okay, let us see.
19/3/2002.
19 award. 62, 62, 62.
19/3/2002.
Not 62. Oh. Okay. It was on which date?
19/3/2002. It's in
The
the,
learned labor court delivered its award on 19/3/2002. Delivered its award in reference case number 20 of 1999. On 19/3/2021. Recording a finding that the findings recorded by the inquiry officer in the domestic inquiry report were not based on the records placed before him by the management. It was held that the dismissal of the two workmen with effect from WF 5/3/1999 was not justified, and they were entitled to reinstatement with full wages. Correct?
Yes.
Full stop. Kara, dissatisfied by the award passed by the learned labor court on 19/3/2002 in reference case number 20 of 1999, the management of Messrs. Doyang Tea Estate preferred a writ petition, WBC number 7040/2002, challenging the same. Full stop. it was contended from the petitioner's side that the findings of the learned labor, the findings reached by the learned labor court were perverse. Full stop. On the other hand, comma, it was contended on behalf of the from the workman's side that a writ court, while exercising its power of judicial review, would not sit on appeal over the findings recorded by the learned labor court. After hearing the learned counsel for the parties and perusal of the materials on the case record, comma, the court observed that this court found that there was no reference to the depositions made by the management witnesses and no analysis of their depositions in the findings that were recorded by the learned labor court. It was noticed that the learned labor court had brushed aside the depositions made by the management witnesses on the ground that there were improvements in their depositions. And this court had observed that the learned labor court, before recording the findings that there were improvements in the depositions made by the management witnesses, comma, ought to have decided, ought to have analyzed the same on the touchstone of the principles involved in a domestic inquiry. Full stop. It was observed that the proceeding involved being not a criminal proceeding, comma, what was required to be established was the preponderance of probability. And it was the duty of the learned labor court to find out as to whether the state principle involved in a domestic inquiry was complied with or not. Full stop. it was found that the learned labor court did not explain as to how the delay of 9 days in lodging the complaint was fatal to the charge against the two workmen. As it was not the case of the workmen that such delay was prejudicial to their defense. Finding that there was no proper appreciation of the evidence by the learned labor court, the impugned award dated 19/3/2002 passed by the learned labor court, Dibrugarh or Assam? Dibrugarh was set aside and quashed. By this court wide judgment and order dated 5/2/2010. Full stop. The matter was remanded back to the learned labor court for deciding the reference phrase on the basis of the evidence on record, by keeping in mind the observations made in the judgment and order dated 5/2/2010, passed in the repetition WBC number so and so. It was ordered that the learned labor court shall decide the reference phrase on the basis of the available evidence. It's running to 61 stroke materials expeditiously. Perhaps on being so remanded back, in the writ petition, where is the impugned judgment?
Award is page 27.
That is not an ex.
And after receipt of the case record, with a copy of the judgment and order dated 5/2/2010, the learned labor court issued notices to both the parties so it was on 28/10/2011, the workman side entered their appearance. before the learned labor court in reference to this number so and so again. The management side of Messrs. Goang Tea Estate entered their appearance on 17/3/2012. Full stop. The Learned Labor Court heard the arguments of the parties on 5/11/2012 and passed the award on 6/11/2012. Holding inter alia that the management side was justified in dismissing the two workmen after holding domestic inquiry. And there was no justification for reinstatement of the said two workmen. Full stop. The said award dated 6/11/2012 passed by the Learned Labor Court, Dibrugarh, in reference case number 20/2019-99 is the subject matter of challenge in this petition.
Then Gazette notification, my lord, 2nd May 2013.
Huh?
Gazette notification, that one has to be gazetted, my lord.
Huh.
So it was 2nd May 2013, the Gazette notification,
Is it part of the record?
a part of the report.
Huh? Part of the record? Repetition,
Writ petition. I've seen somewhere.
which page? Repetition. Which page? Gazette,
Gazette, 2nd May, my lord.
which page? Record.
I- My lord, para 14,
Para,
writ,
then let. Fine, I go to. Para 14.
para 14. Internal page 5.
Of who, where?
Writ petition, para 5.
Para?
5.
Five.
14.
Para
Page five.
14. Okay. The government of Assam published the award dated so and so in the official gazette. Published the award by notification number. Para 14 or dated 2/5/2013 in the official gazette. It is a so and so, it's a subject matter. Oh, chilling this is. Okay, we'll resume after 2 minutes. I think presiding officer is not to be heard.
No.
And Mr. J. Roy, our senior counsel, assisted by Mr. B. Sharma.
B Sharma.
B. Sharma.
B.
लिखिए Learned Counsel for the response number 1. Yes, MS Borosa, in the face of this law, what is your submission?
My lord, my submission is that, my lord, learned labor court, my lord, before going into the merit of the case, my lord, there must be a finding on the domestic inquiry, my lord, and there is no finding, and I am supported by Delhi Close Mill, my lord, good pushing. Paragraph 61.
MS Bhattacharya, learned counsel for the petitioner, has submitted that the learned labor court had proceeded in proceeded erroneously to decide the reference by discussing the evidence laid by both the sides before it, comma, without arriving at a finding about the validity of the domestic inquiry caused against the two workmen resulting in the order of dismissal by the management. Full stop. MS Bhattacharya has fairly submitted that the learned labor code ought to have made or to have reached a finding about the domestic inquiry process at first, and it is only after reaching a finding as regards para 61.
61.
On merits, comma, he could have, the learned labor court could have proceeded to discuss the evidence adduced before it. Full stop. In response, Mr. Roy, learned senior counsel, appearing for the respondent number 1, that is the management side, has agreed.
In fact, labor court got confused with about the domestic inquiry and his own inquiry matter.
Has also submitted in similar lines. Full stop. It is the submission of Mr. Roy that the principles are well settled as about the manner how the learned trial court has to proceed in respect of a reference where there was already a domestic inquiry conducted by the management side leading to the dismissal of the two employees. The learned counsel for the parties have also referred to a number of judgments of the Honorable Supreme Court of India, which will be referred in the later part of the order. Full stop. Para. The facts recorded the sequence of events, how the sequence of events which have preceded passing of the impune award have already been recorded here in both. Full stop. An alleged incident which occurred in the factory premises of Messrs. Doyang Tea Estate on 5/10/1998 had led to the issuance of a charge sheet against the two workmen on 28/10/1998. Full stop. On perusal of the case records, it is noticed that during the course of domestic inquiry, the inquiry officer recorded the depositions of how many? Forgot. I forgot.
Provision there is 6, my lord.
6 witnesses. And in rebuttal, to rebut such depositions, the workman side had also adduced the evidence of
They themselves given the witness, my lord.
2 witnesses.
No, they themselves. my lord.
The 2 workmen had themselves adduced their evidence. Full stop. It was after recording of evidence depositions of 6 management witnesses and the 2 workmen, the inquiry officer submitted his domestic inquiry report on so and so. I got it.
MW, my love, 5 witnesses, not 6, 5 witnesses.
5
Management side, management,
or MW 5.
labor code side.
5. 6. 6.
6. That
6.
is a domestic inquiry.
Domestic inquiry. 6. on 30/12/1998. This court. No, on perusal of the domestic inquiry report. On perusal of the contents of the domestic inquiry report. Which is available in the case record and which has been exhibited as exhibit number 16 in reference case number 20 of 1999, it is noticed that the inquiry officer had discussed the depositions of the both the management witnesses, discuss the depositions of the witnesses from the management side as well as from the workman side. Full stop. It was after discussion, it was after discussion of the depositions of all the witnesses, the inquiry officer recorded his findings and held that charges were duly established. And the two workmen were guilty of misconduct under the standing orders in force in the key estate. Full stop. In at this stage, it is apposite to discuss it. It is apposite to make a survey of the principles required to be followed in a domestic inquiry held by the management, as laid down by the Honorable Supreme Court of India in different decisions. In Delhi Cloth and General Mills Company versus Lud Bud Singh, reported in 1972, 1 SCC 595, the two contentions raised were as follows. A2A. After discussing a number of previous decisions, the Honorable Supreme Court of India has formulated the principles that had emerged therefrom as under B2P paragraph 61. Paragraph 61?
61. Paragraph 4.
Wait a minute. B2P, huh? So meaning thereby the tribunal has to, court has to ask, I think, the management principle here that tribunal had allowed both the parties to lead evidence before it.
First, he has to see that evidence of the domestic inquiry.
It can be done. It can be done.
Yeah.
But the management has to be asked whether you'll be relying upon the domestic inquiry or would be relying upon the evidence before it.
Subpara 4, my lord. When a domestic inquiry has been held by the management and the management relies on the same, it is open to the letter to request the tribunal to try the validity of the domestic inquiry at a preliminary issue and also ask for an opportunity to adduce evidence before the tribunal. If the finding on the preliminary issue is against the management, it is the duty of the management to ask for the
But domestic, if a domestic inquiry has been held,
If request is
let us go one by one.
if request is not made, my lord, learned tribunal cannot show moto, my lord. Request is to be made by the management, my lord, for adducing evidence, and that and the recent.
No, Roman, I'll come to the later decision later on. Because one court has held, Supreme Court has again subsequently held that labor court has no jurisdiction to directly go to the,
Yes.
in the presence of a domestic inquiry report, the Honorable Supreme Court has held that the labor court does not have the jurisdiction to go
Unless-
directly to the,
Unless,
Request
unless,
has to be come from the management, my lord.
no, that is not, the subsequently it has been clarified, so I'll refer to that. Let us go one by one
if
to understand.
if no
One.
domestic inquiry,
If no domestic inquiry, principle one,
yes,
if no domestic inquiry had been held by the management,
or if the man,
or if the management makes it clear that it does not rely upon any domestic inquiry that may have been held by it, it is entitled to straightaway adduce evidence before the tribunal justifying its action. So here domestic inquiry has been held
yes,
and management has not made it clear that it will rely.
yes, so first will not come.
Now, not now.
Second matter.
Second, let us see
If a
second
domestic inquiry had been held,
held.
it is open to the management to rely upon the domestic inquiry held by it in the first instance and alternatively and without prejudice to its plea that inquiry is proper and binding, simultaneously adduce additional evidence before the tribunal justifying its action In such a case, no interference can be
No
drawn.
inference.
Inference can be drawn without anything more that the management has given up inquiry conducted by it.
So this principle is also applicable. No inference can be drawn
Hmm.
by the labor code that they have discarded their domestic inquiry. Right?
Right.
Then 3,
Then three, when the management relies on the inquiry conducted by it and also simultaneously adduce evidence before the tribunal without prejudice to its plea that the inquiry proceedings are proper, it is the duty of the tribunal in the first instance to consider whether the inquiry proceedings conducted by the management are valid and proper. If the tribunal is satisfied that the inquiry proceedings have been held properly and are valid, the question of considering the evidence adduced before it on merits
no longer
no
survives.
longer survives.
So I think 2, 3 are applicable in the case.
Yes.
If the tribunal is satisfied that survives, it is only when
When the tribunal holds that the inquiry proceedings have not been properly held and in
then it derives
in case
jurisdiction.
it considered evidence received, then
Right? This is 2 and 3.
Yes.
Is it not? It derives jurisdiction to deal with the merits of the dispute. And in such a case, it has to consider the evidence adduced before it by the management and decide the matter on the basis of such evidence. Then 4,
when domestic inquiry has been held by the management and the management relies on the same, it is open to the letter to request the tribunal to try the validity of the domestic inquiry as a preliminary issue and also ask for an opportunity to adduce evidence before the tribunal. If the finding of that on the preliminary issue is against the management, however elaborate and cumbersome the procedure may be, under such circumstances, it is open to the tribunal to deal in the first instance as a preliminary issue the validity of the domestic inquiry. If it finds on the preliminary issue is in favor of management, then no additional evidence need to be cited by the management. But if the finding on the preliminary issue is against the management, the tribunal will have to give the employer an opportunity to cite additional evidence and also given similar opportunity.
so it is another situation where
the
it first deals with the domestic inquiry, right? Finds that it is not proper, then management will be asked to lead evidence before it. So this situation is not there here in this case.
Over by 3, right?
Then principle 5,
Principle 5 is the management has got a right to attempt to sustain its order by adducing independent evidence before the tribunal, but the management should avail itself of the said opportunity by making a suitable request to the tribunal before the proceedings are closed. If no such opportunity has been availed of or asked for by the management before the proceedings are closed, the employer can make no grievance that the tribunal did not provide such an opportunity. The tribunal will have before it only the inquiry procedure.
I think it is 2 and 3. Both are available now. Edit. Do you have the Firestone? Do you have the Firestone case?
Not
1973 1 SSC 813.
with us, madam.
Some more principles have been laid down in similar manner. Let you go. Let you go. The scope of the scope of the labor code under the Industrial Disputes Act 1947 came up for consideration. Also in Walkman versus Walkman of Firestone Tire and Rubber Company of India Private Limited versus the management and others, reported in 1973, 1 SSC 813. Full stop. The Honorable Supreme Court of India had held therein that in terms of section 11A of the Industrial Disputes Act, Industrial Disputes Act 1947, if a domestic inquiry has been held and finding of misconduct is recorded, the authorities under the Act have full power and jurisdiction to reappraise the evidence and to satisfy themselves whether the evidence justifies the finding of misconduct. To stop. It is only when the inquiry is found to be defective, it has been held that it is only when the domestic inquiry is found to be defective, the employer can lead evidence to prove misconduct before the learned labor court. Before the labor court. এইটো Delhi clock printer আগত Delhi clock printer আগত দিব পাৰা the powers of labor court to give appropriate relief in case of discharge or dismissal of workmen have been laid down in section 11A of the Industrial Disputes Act 1947. First of all, the reference, section 11A of the Industrial Disputes Act 1947 is quoted here under. Firestone, no? In paragraph 32 of the judgment, the Honorable Supreme Court of India has found after discussing a number of precedents, the principles emerging therefrom as under para 30. C2C. The issue as to whether the management is required to seek liberty to prove misconduct in the written statement or could lead evidence at a later stage came up for consideration before a constitution bench of the Honorable Supreme Court of India. In Karnataka SRTC versus Lakshmi Devamma, reported in 2001, 5 SSC 433. আসেনি কি টু লাইট না ডাঙৰ নেকি 2001 5 SSC 433. ডাঙৰ নেকি It has been held as under accused judgment of D to D as a D to D. Paragraph 17 and 18. It is also well settled that since the domestic inquiry is not by a court, therefore, strict rules of the Evidence Act 1872 are not applicable to such domestic inquiry. Full stop. A 3-judge bench of the Honorable Supreme Court of India in the case of state of Haryana versus Ratan Singh, 1977 to SSC 491 has discussed as to how the evidence laid in a domestic inquiry are to be appreciated. Because it has been held as under each week. Liver cortisol. কিন্তু কি আছে এই স্ট্রিক্ট রুল অফ এভিডেন্স কিন্তু কি আছে এই লাইন থাকো it is the labor code has to is under obligation to examine whether the domestic inquiry was conducted in accordance with the principles of natural justice and a reasonable opportunity was given to the charge-sheeted workman to lead evidence in support of his defense. Full stop. If it appears to the domestic, if it appears that the domestic inquiry was not conducted in accordance with the principle of natural justice and a reasonable opportunity was not given to the charge-sheeted workman to lead evidence in support of his defense, that could be a valid ground on which the labor court, on which a labor court can discard the finding of the domestic inquiry, that the workman was guilty of misconduct, and to consider the matter on the merits uninfluenced by such finding. Full stop. The standard of proof in domestic inquiry is preponderance of probabilities and not proof beyond reasonable doubt. Full stop. The labor court does not act as if it is an appellate body to appreciate the evidence. Full stop. It is settled that where two views are possible on evidence, comma, the labor court should be used to be has to be slow in interfering with the findings arrived at in the domestic inquiry. Full stop. On the basis, in the face of such principles of law, comma, when one looks at the award dated 6/11/2012, passed by the learned labor court in reference case number 20/2019, comma, it is noticed that it was pleaded from the workman's side that the domestic inquiry was not initiated in accordance with the principles of natural justice. Full stop. Recording, just by recording such plea from the workman's side in the award dated 6/11/2012, comma, the learned labor court had proceeded to discuss the evidence of the 5 management witnesses and the depositions of the 2 workmen, comma, laid before it to arrive at the finding, comma, mentioned herein above. Full stop. Delete. It is the case in hand is one where the depositions of 6 management witnesses and 2 workmen laid before the inquiry officer in the domestic inquiry, and the domestic inquiry report dated so and so were available before the learned labor court. Full stop. The depositions of 5 management witnesses and 2 workmen, comma, laid before the learned, laid before it after the reference made by the government of Assam on 26/11/2019 were also available before the learned labor court. Full stop. In such fact situation obtaining, comma, the learned labor court ought to have comma, in the first instance, comma, proceeded to consider as to whether the domestic inquiry proceedings conducted before the management side were valid and proper or not. Full stop. It is only in the event that the labor court, after reaching a satisfaction that the no, if after such consideration, comma, if the labor court reaches a satisfaction that the domestic inquiry proceedings had been held properly and validly and are valid, comma, the question of considering the evidence adduced before it on merits would not survive, as it is settled that it is only when the labor court holds that the inquiry proceeding have not been properly and validly held, it derives jurisdiction to deal with the merits of the dispute by discussing the evidence adduced before it. Full stop. Hence, thus, comma, as the labor court, while recording the finding in the award dated 6/11/2012, had confined itself in considering only the evidence laid before it, without reaching any finding as regards validity of the domestic inquiry report, comma, this court is of the unhesitant view that the award dated 6/11/2012 is not sustainable in law, and the same is liable to be set aside and quashed. It is accordingly set aside and quashed. Full stop. The matter is remanded back to the labor court, Dibrugarh, to decide the reference, that is reference case number 20/2019, in conformity with the principles required to be followed in a reference of such nature. Full stop. For the purpose of facilitating an expeditious consideration of the reference, comma, both the parties shall appear before the learned labor court, Dibrugarh, on maybe on the first week of October.
First week of October, then the date may be fixed.
Third of October,
Third,
3/10/2023. With a copy of this order. Full stop. Upon appearance of the parties before it, the Labor Court, Dibrugarh shall proceed to decide the reference in an expeditious manner.
Uninfluenced with the observation, uninfluenced with the observation means.
I have not made any observation
No, there's,
against any of the parties. Made any observation.
yes, no,
I have always I have said preponderance of probability.
thing, so
I have said, I have not commented nothing. Full stop. It is, however, it is made clear that none of the observations, any of the observations made in this order are for the purpose of testing the validity of the award
Yes.
dated 16/11,
6/11 to
16/11, 6/11/2012, and none of such observations shall be construed to be observations on the merits of the claims of the respective parties. Am I clear?
Madam, may I pray for a time bond?
That is
Within
experience,
Must be
preferably.
within a period.
Only to, he has to, only to
Only
discuss the
here.
evidence.
only to here.
Preferably within a period of 3 months from the date of such appearance. That will do.
Alright.
My lord, I think 15 can it be taken up on any other day, my lord, because second half of I have some. On 12th.
15.
15 item.
We have to see on which date. Let us see.
12 or 14, my lord.
Let us see. Let us.
Yes.
Zian Sawala, Senior Counsel for the Petitioner, KP Pathak, Sending Counsel APDC. Have sought for a listing of the case. 26/9. 26/9, 2022. Full stop. As sought for by the learned counsel for the parties, list the case on so and so. To Ikini Anile. Yes, where is Das?
My lord. Yes,
Mr. Das.
he has deserted us after lunch.
Huh? Oh, some 5 minutes accommodation.
So, my lord.
Oh. Yes,
My lord. Here,
let us have a look at the agreement itself.
my lord. I'll just take your lordship to the admitted facts, my lord, where there is no dispute and which are relevant to this case, my lord. My lord, may kindly come to page number 22. That is the letter of acceptance. Now, my lord, this letter of acceptance was issued in 2006, 12/12/2006. This is the name of the work, my lord, subject. This is the Bhogibil project, my lord, in Dhemaji, that connecting Dibrugarh and Dhemaji, making of embankments. And the total value of the tender, which is there at the first paragraph, the lordship will find it is 18 crore 74 lakh 69,000. This was the total value of the work. Now, my lord, after acceptance, a formal contract agreement was signed between the parties. My lord will find the contract agreement at page 30. Page 30 is the formal contract agreement which was executed between the parties on 6/3/2007. This is the contract agreement. Now, my lord.
Yes.
Now, my lord, before I come to the vitiation part, my lord, I'll just take your lordship to page number 102, which will indicate that the work in question was completed to the satisfaction of all concerned. 102, it is a completion certificate issued. Page number 102. The work was completed on 31/1/2009. And that was the total CA value, date of commencement, date of actual completion, and this certificate was issued on 29/7/2009. So there is no dispute with regard to the work. Now, my lord, after completion of the work, my lord will kindly come to page number 103, my lord. What had happened, my lord? Here, initially, my lord, hypothetically speaking, initially, for example, my lord, the contract was for construction of 100 units. After completion of the work, it was seen that, in fact, only 17 units were required and therefore 17 units were constructed. So there was a variation to the tune, and because of this variation, the contract value from 18 crores have scaled down to 12 crore 86 lakh. We have no dispute to that.
1 minute. Yes.
My lord, the contract value have scaled down from 18 lakh 74,000, 18 crore 74 lakh to 12 crore 86 lakh. We have no dispute to that as well. Now, because there was a variation, my lord. Now, my lord, the petitioner, since he has done work worth rupees 12 crore, therefore he has admitted that fine, I'm happy if you give me 12 crore, because it is an admitted fact that there was a negative variation on the negative side. But the problem started with page number 103, the last line. This is for your information and requested to obtaining no objection certificate from contractor to recover the vitiated amount of rupees 25,21,881. Here the problem starts, man. That from where how they have calculated this vitiation amount, my lord, it is there in the writ petition, but just before going to the vitiation amount, from page number 104 to page number 108 is the variation statement, which is in my respectful submission, which is not relevant for this case, my lord. How the quantities varied, my lord. That is because there is no dispute to that, my lord. Now, they calculate the vitiation amount another letter they write to us at page 110, claiming the same thing, that either you submit 25,21,881, page number 110, my lord, or you give a no claim certificate for deducing, for deducting the same from your final bill. Then there is a letter from the railways, my lord, at page number 111, where, my lord, they have calculated the vitiation amount by comparing my rate with the rate of the second lowest tenderer, whose tender they have rejected in 2006. Page number 112, lordship will see a table is given where my rate and the rate of one Jaichand Lal Singh was compared, and they have come to a conclusion that if the work would have been allotted to Jaichand, then the railway would have saved money. Therefore, I will be paid at the rate quoted by Jaichand.
Okay, 1 minute, let me read.
My lord, my lord.
Yes.
Now, my lord, will kindly come to page 113, which is a part of this communication which started at 111. Now, here, my lord, the railway have said the original contract value 18 crore 74 lakh such and such, final variation value 12 crore 86 lakh 54,000 such and such. Percentage of variation is minus 31.37. Vitiated amount is this much. Now, my lord, the next sentence is important. It is the railway's own letter, my lord. the final variation amount decreased beyond 25% from the original CA value as per SOP 21.2 provisions. This contract may be treated as a single tender with finance concurrence if the amount decreased beyond 25%. That if there is a minus variation of beyond 25%, then it will be treated that as if my client is the single tenderer, so that his rate cannot be compared with any other tenderer. In other words, if I am the single tenderer, then there is no rate with which my rate can be compared. So if the variation is beyond minus 25%, then this is what the railway circular says has to be adopted. And here the variation was minus 31.37%. That is much below beyond minus 25%. So that is what they say, my lord. The same thing has been resonated at page number 114. My lord, is there at 140? My lord, this is the note. For decrease in quantities of individual item up to 25% of the quantities specified in contract, no finance concurrence is necessary. For decrease in quantities of individual items beyond 25% or decrease in contract value beyond 25% of the original contract value, finance concurrence and no claim certificate from contractor is necessary. It should be certified that quantities proposed to be reduced will not be required in the same work at a later stage and will not hamper the safety of work. Now, 4 is important. It shall be ensured that due to decrease in quantities, tender is not vitiated in case of vitiation of contract, sanction of competent authority with finance concurrence. A single tender should be obtained. So they say that if the variation is beyond 25%, then it should not be vitiated. I'll come to the vitiation part, my lord, because, my lord, in my limited understanding, clause 6 does not communicate the meaning which they are trying to project after completion of the tender. Now, my lord, will kindly come to a Government of India Ministry of Railway Board at page number 115. This circular is with respect to enhancement of original tender value, but there is a mention as to what would happen if there is a decrease in the tender value after execution of the work.
Let me read it.
My lord, my lord.
Yes, next page.
Yes.
116.
116. My lord may skip 116 as well, my lord. My lord may come to 117, column number C. This is
I'll not skip that. Let me read and understand.
absolutely, absolutely.
Yes.
Now, my lord, I am covered by page 117C. Because 117C is with respect to decrease in the quantity of work. And as far as page 115, 16 and the former part of 117, these are when the tender value escalates. But when the tender value decreases, then C. Here also the same thing is reiterated. In case of the last line, in case of vitiation of tender, sanction of competent authority as per single tender should be obtained if the decrease is beyond 25%, and admittedly in my case the decrease is
This
beyond.
I have not understood. What
Yes.
is single tender?
I'll try to, my lord, I'll try to make it. My lord, the very idea of vitiation which they have come up after execution of the work is to compare my rate with the second lowest tenderer. So if I am treated as a single tenderer, then they will not have any other tenderer with whom my rate can be compared. That is precisely why, my lord, I had given an. If your lordship kindly, I beg my lord's indulgence to page number 9 for a while of my petition, my lord. Page number 9. This is what they are projecting
Under the vitiation clause.
under the vitiation clause. This is what they are projecting at page number 9. My lord is there at page 9. My lord, these are the two tables which I have prepared, my lord, just to explain, my lord, how they're doing this vitiation. My lord, items and quantities first table, items and quantities as per tender notice contract agreement.
Let me read you what the explanation you have given.
Para 7, my lord.
Yes.
My lord, that is precisely this table, my lord. I've tried to, I've tried to explain, my lord, how they are doing this. They are now, in short, my lord, they are trying to pay me at a rate quoted by my rival tenderer, which rate they have discarded at the very initial stage, my lord. Now, my lord, my challenge to these communications asking for NOC is twofold, my lord. One is that the vitiation clause which appears at page number 50 does not speak of page number 53, clause number 6. This clause 6, my lord, vitiation of contract, my lord. That this clause says the contract shall not be vitiated by any inadvertent error of any kind in the surveys, information, specification, drawing, or schedule of quantity. However, during execution of work, if variation of quantities against item of work becomes inevitable, and such variation causes vitiation of the contract, the amount of vitiation will be deducted from the contractor's bill. Now, my lord, this clause 6 does not connote any idea regarding comparing my rate with my rival tenderer and then paying me at the rate of my rival tenderer, my.
Now, what is the stand they have taken?
Yes, my lord. Now, they have come up in their affidavit that it is their policy that L1 will always remain L1. And their affidavit, my lord, I am reading para number, rest are all admitted, my lord. Probably, my lord, the relevant reply would be at para 13 and 14 at page 4.
13 and 14.
13 and 14.
You stop for a moment. Mr. Das,
My lord,
you are harping on this clause 6.
my lord, yes, my lord.
Page 53.
Right,
There is basically one line.
that's correct.
However, during execution of work, if variation of quantities against the item of work become inevitable and such variation cause vitiation
Yes,
of the contract, the amount of vitiation will be deducted from the contractor base.
my
Now,
lord.
have you explained anywhere what vitiation is?
My lord,
In the contract. First, I have,
yes,
in the contract,
in the.
one by
contract-
one. I am asking queries, you just answer one by one.
My lord, yes, so,
Have you explained what is vitiation? You have defined many words
yes.
in the GCC or special conditions of
Right,
contract.
right.
Let us see.
My lord,
Come to, you confine to my queries.
Right.
Then you make your submission.
yes,
Come to page 39. You have explained some given some definitions, interpretations, right?
Right.
Page 39.
Right.
Clause 1.0, definitions and interpretations. Right?
yes.
I think that is what. This is additional special conditions of contract,
Contract.
right? Where is the contract otherwise?
Page number 30.
30.
Correct.
So this is the contract.
My lord,
So it include general conditions of contract,
contract, yes, ma'am.
special
Con-
specifications of the Northeast Frontier Railway 1998 edition, corrected up to date, and special conditions and specific specifications,
My lord.
right? So what are the general conditions of contract? This is additional. Page 39 is additional special conditions of contract,
But this is as per the. GCC.
right?
Yes. Yes, this is like person.
There, then what is this, Mr. Biswas, page 52 onwards?
Page 52. These are,
Because 51,
yes, my lord,
it ends.
51.
The previous document ends.
My lord, these are all part of the,
No. Okay, 3.1.
this is,
Okay. Okay,
this is a pro forma,
Okay,
my lord,
okay,
how a
okay.
completion certificate is to be given.
okay. So contract agreement consists of general conditions of contract,
My lord.
specifications, and special conditions and special specifications, if any. And plus also you have made this page 39, additional special conditions of contract, part of the contract agreement.
My-
Now, except clause 6.0
Yes,
at page 53,
my lord.
in the additional special compact of contract,
My lord.
whether there is any mention of vitiation in the other documents.
My lord,
Am I clear?
yes, my lord. Correct. My lord. My lord, so far this clause is concerned, my lord, 6.0. That has been brought into, my lord, on the basis of the earlier direction, my lord, I got the instruction also, my lord. On the basis of, my lord, circular 55/1995, my lord. There is a circular. Already there is a 1995, my lord.
That is part of the. report.
Yes, part of the record also, my lord. Yes, correct. And this is the circular they have said, my lord, we based on this. Now, my lord, para 3 of the circular, we may.
Para 3 will come later on. But whether that circular has been made part of this contract agreement. You are authorized to read that circular. Because circular, let us see the circular,
Yes, my lord.
page
Each lordship,
95 circular, you have made
yes.
part of it.
part of it. Page 116, my lord, directly, 115. 116.
Yes, that's Ministry of Railway Boards, my lord.
116.
105, 115, sorry.
Now, my lord, annexure 1 that.
Yes.
We'll come to annexure 1 later on.
My-
This is a circular issued to containing directives
Yes, my lord. but
to
issued
the
by
railway authority.
Railway board issued, my lord. to the
Railway board has
authorities.
issued.
And now, my lord. Now, my
This,
lord.
this has to be made part of the contract.
Right. My lord, my submission is basis of vitiation clause is, my lord. Now, second page, my 160.
To bind the contractor,
Yes.
this has to be made part of the contract.
But.
Have you gone through, Mr. Das? Because
scope is there,
subsequent to the hearing, conducted on the previous date, I had the occasion to go through many
It
documents,
is, right.
and mainly railway contracts, right? Then I have seen this document.
In another railway.
Mr. Gugoi, Dr. Gugoi has shown me one railway board circular policy dated 8/2/2018. Have a look at this. Something inside the file somewhere. See the clause. Aspect of variation. See, turn the first page. Explain or not. Then below,
Percentage difference between, remember this is important, first 67.
well, important.
Huh.
It is part of the contract
Yes, yes.
agreement.
Percentage
Which
between.
The
Person
contractor has
contractor
signed with his eyes
This
open.
resulted in variation.
It is important, but that contractor has signed that contract agreement with his eyes wide open, knowing that this is a part of the contract. And see the reference,
Man.
see the reference there? That reference has been made to this policy, which Mr. Dr. Gugoi has handed over to me in the morning. So it has been, this circular has been made a part of the contract agreement, that contract agreement. Now, you have a circular of 1995.
Man.
Was it not your duty? Because it is not a gazetted notification.
Well, that's correct, but.
You cannot bring, suppose somewhere file, somewhere authority has been given to the railway authorities, and Mr. X, the contractor who bona fidely executing the work, do not know what is the implication about the decision you have taken inside a file. How was your not duty
That's correct.
to notify him, to bring to your his notice,
That absolutely correct.
right? Just a word, vitiation, without any explanation, what is vitiation?
Man.
How can you bind a contractor? Rules of the game are fixed at the time of contract agreement, right? If you want to bring some subsequent changes in the contract agreement, then there has to be a supplementary agreement with the consent of the contractor.
One submission, my lord. 116, third paragraph, let me read, my lord. Because my fourth paragraph, my lord, 116.
That
How-
is why I am
how
asking
you do,
you.
my lord?
That is to
Yes.
read this,
Yes,
into your submission.
yes.
Have you brought this circular to the knowledge of the petition?
Uh,
You cannot read that 116
Because, my lord, this.
without satisfying me, satisfying this court that this circular of 5/5/1995 has been made a part of the contract agreement,
My lord, my submission. to
which
the
was
query
executed
is
in
that, my lord,
2006.
My submission is that, my lord, that as per this 5/5/1995.
No, I'll not read.
Our was.
I'll not hear. I'll not hear on that pen. First, you tell me
Right.
that this circular has been made. That is why I have pointed out to you.
So far the
I have
vitiation is
pointed out
concerned-
to you that
Yes.
contract agreement comprises of GCC plus
A
plus
special,
plus
special.
plus plus plus.
1990
Am I
and 19.
clear?
Yes.
So both of you had executed all those documents with your eyes open.
Mal.
That is why I made a query whether vitiation has been, the concept of vitiation has been explained in any of those documents. GCC
Ah.
or special condition of contract or additional special condition of contract, except this clause 6.0 anywhere. Don't read 116 without satisfying me that this is a part of the contract.
My lord, now, my lord, that the general standard special condition of contract
6.0 I have seen.
1998 and 1993, there are two booklets, my lord. NFR general.
Am I been able to convey
Ah.
what I am exactly asking?
My lord, here apparently in the tender contract agreement, my lord, that
Apparently will not do, yes or no, that's all.
6.0 is the, my lord.
Only one.
So
I have
far
to
the
record your submission.
vitiation
I
is
have to
concerned,
record and record your submission.
my lord.
Perhaps, however, apparently this will not do. Yes or no?
My lord, the 6.0 is there, my lord. That's
all.
That's all. And
I'll
moreover-
record that submission.
Yes, 6.0, so for vitiation, and Mala, how we calculate the vitiation?
I'll not go into it.
Fourth para of 116, we Mala,
We have to examine the case on the touchstone of Article 14 of the Constitution.
no, Mala, that submission I may be allowed to make, Mala.
Which of you? Though I'll record, though
No, no,
Mr.
so-
Das has referred to the so-and-so, the contents of
Yes.
circular so-and-so, that is not acceptable.
That's correct. And moreover, Mala, I may be.
That you have referred, court has discarded.
Mala, three more Mala judgments, Mala, I may be allowed to place me.
No,
On
tell
this-
me on the basis of this. You can proceed only on that. We do not want to burden
I
with
cannot-
unnecessary.
I cannot develop the case, Mala. what
We
is
will not
there on
burden
record.
the order.
That's Mala, 6.0 along with, yes, Mala.
Take a reading of your judgment. Thereafter, you really get satisfied.
Mala.
Yes, even for the purpose. Am I clear?
Mala.
Am I clear?
Mala. Mala.
Go through it and tell me.
Yes.
Just handing over a judgment will not do.
That's good. I will place me.
If it is really relevant, first
I
tell
found-
me on the point.
I
No,
found
no, I'll
relevant,
not
Mala,
see.
yes, Mala.
Tell me on what point? Vitiation.
No, not on vitiation.
Man,
Not on vitiation, my lord. Our argument was that, my lord, is a concluded contract, my lord. In a concluded contract, the
show me,
Perhaps-
have you raised the point of maintainability in your repetition?
that is also problem, my lord. At
That is
point of
also
time,
problem.
I was not the advocate there, my lord.
Show me the law when a number of years have elapsed and the repetition is pending without raising the question of maintainability, then the writ court has no other option but to proceed.
1972 SCC 355, Hidayat Narayan versus Income Tax Officer,
What is the
para
exact,
number 12.
what is the exact content of para number 12?
Para number. Page number.
I do not want to hear unnecessary points.
Absolutely, absolutely. That is why precisely the paragraph. Come to paragraph.
If a point is taken, it should be taken, preliminary point on maintainability, it has to be taken at the first instance.
Person. The problem is that at the time, my lord, that the affidavit was adopted by someone and later on that file has been handed over, my lord. That's the problem.
This has to be dealt with, Mr. Biswas.
Yes.
This issue is required to be dealt with.
That's right.
Otherwise, they are,
My lord, here,
am I,
exactly same nature of
Mr. Biswas?
Yes. Yeah. Uh-huh.
So they are.
Uh-huh.
The instant writ petition under Article 226 of the Constitution of India has been preferred to assail a final variation statement made against a contract agreement dated 27/2/2007 issued by letter number page 103 dated 08/12/2010. Two. A letter bearing number so and so dated 3/11/2011, page 110. And a letter bearing number so and so dated 5/11/2011, page 111. Issued by the NF Railway, respondent NF Railway authorities, comma, apart from challenging clause number 6.0 of a contract agreement executed between the petitioner and the respondent NF Railway authorities on 6/3/2007. Laws cannot be challenged in repetition,
right, my lord.
right?
And my lord, to that
This
effect,
is-
my lord, I was supposed to point out my judgments, my lord, 3 judgments. My lord, for
Clause, no.
just for referring, my lord.
Clause cannot be, I have made it clear. I am not,
Yes,
I am not,
I got your point, my lord. For recording, my lord,
setting aside clause 6.0,
my lord, yes.
but I have indicated 1 to 3.
My lord, why?
Mister, there are, you want to pardon the judgment, there are 100 judgment against you,
Yes, my lord, yes.
right? Right from Sri Lanka Vidyarthi, Marpatia, all are there. It is not always necessary to pardon a order.
My lord, because my lord, Honorable Supreme Court in a case, my lord, yes, they say.
Show me vitiation clause.
No,
I have
not all.
said, I have already indicated 6.0 cannot be challenged in
No,
repetition.
that's
Am I
correct,
clear?
my lord. Yes.
Known as unnecessary submission beyond pleading.
Fine.
No unnecessary submission beyond pleading. I am already dictating.
Sorry.
The undisputed part. Still open for you one day. Exactly on the point, not unnecessary. The background facts. Leading to the issuance of the aforementioned letters can be, it is necessary to state the background events which have led to the issuance of the aforementioned letters, comma in brief at the inception. The respondent railway authorities, NF railway authorities, comma, provide page 22 tender number invited tender number আছে হ্যাঁ কই না থাকবো আলো দেখে দিচ্ছি invited bids from eligible bidders, intending and eligible bidders for a contract for quote unquote raising A to A. End over ZR.2 unquote. In the year 2006, full stop. Responding to the tender number so and so, comma, the petitioner submitted. Petitioner which is a joint venture concern of two entities, comma, submitted its offer on 14/8/2006. Full stop. The offer of the petitioner was accepted by the competent authority in the respondent NF Railway at a total cost of rupees 18,74,69,000. As quoted by the petitioner. And an acceptance letter bearing number case 22 dated 12/12/2006 stood issued under the hand of the chief engineer, comma, NF Railway Maligaon. O/O, the general manager, CON Maligaon, Guwahati, page 20. With the issuance of the acceptance letter, comma, the petitioner was authorized to commence the work on the strength of the said acceptance letter to ensure completion of the contract work within the stipulated period of time, mentioned therein. Full stop. By the acceptance letter, the petitioner was asked to deposit earnest money to the extent of rupees 34,09,540 and to execute a formal contract agreement for the contract work within a period of 15 days therefrom. Full stop. As part of the state acceptance letter, this schedule was part of that. Please keep an eye on the documents.
Yes, it is.
This schedule was also part of this.
Schedule, Yes, sir.
And article and two. A schedule of items of works and approximate quantities. According to it was made a part of the acceptance letter dated 12/12/2006. The respondent, it was mentioned that the acceptance letter shall be legal and enforceable contract between the petitioner and the respondent railway NF railway authorities. Full stop, para. Subsequent to deposit of the earnest money and compliance of other requisite formalities, a contract agreement bearing number CON stroke Bogeyville stroke 120 came to be executed between the petitioner on one hand and Chief Engineer Construction 3 NF Railway for and on behalf of the President of India on the other hand. As per the contract agreement number so and so dated 27/2/2007, the petitioner as the contractor had agreed with the NF railway authorities for performance of the contract work set forth in the schedule thereto, which one, the general conditions of contract. Two, the specifications of the Northeast Frontier Railway 1998 edition corrected up to date. Two, and three, the special conditions and special specifications, if any, as part of the contract agreement. As per the contract agreement, total approximate value of the contract work was rupees 18,74,69,000. One set of additional special conditions of contract was also made part of the contract agreement number students. And clause number 6.0. In respect of which the petitioner has mounted a challenge, comma, is part of the said additional special conditions of contract. Full stop. What is the next page you have taken me? Okay.
Completion certificate. Page 102.
On being awarded the contract work, comma, the petitioner proceeded to execute the contract work whose in due course of time, comma, it had completed the contract work, comma, which was inspected by the concerned authorities in the respondent railway, NF Railway. Full stop. A completion certificate bearing number 102 dated 29/7/2009 stood issued under the hand of the Deputy Chief Engineer, NF Railway, certifying that the petitioner had successfully completed the contract work against contract agreement number so and so dated 27/2000. Full stop. The certificate also contained the detailed expenditure of the work. Full stop. And it mentioned that the date of commencement was 26/12/2006, and the actual date of completion was 31/1/2009. Full stop. The certificate further mentioned that against the original contract agreement value of rupees 18,74,69,000, comma, the up-to-date value of bill was rupees 11,29,08,422. Full stop. Mention was made in the said certificate to the effect that the final variation of the above contract agreement was under process for finalization, whereas the overall progress of work achieved was 100%. Full stop. It was on 8/12/2010, comma, the respondent railway authorities, a white letter number is 103. Issued a final variation statement against contract agreement number so and so dated 27/2007. Full stop. As per the said, as per the final variation statement, comma, which was shown to have been approved by the competent authority in the respondent NF Railway, comma, that there was negotiation with the contractor, i.e. the petitioner towards final variation statement against the contract agreement number so and so, dated so and so. And it was agreed that the revised value of the revised value in respect of the contract work would be rupees 12 crore 86 lakh 54,574.39. Full stop. The petitioner has taken exception to a statement contained in the said final variation statement to the effect that the authority issuing the said final variation statement had requested the Deputy Chief Engineer Construction to NF Railway to obtain a no objection certificate from the contractor, i.e. the petitioner, to recover an amount of rupees 21,881.27 on the ground, on the premise that the said amount was recoverable as the contract agreement stood vitiated to that extent, correct? T1 2000. The final variation statement dated 8/12/2010 was followed by a letter dated 3/1 by a letter bearing number so and so dated 3/1/2011 110. Comma addressed to the petitioner. Full stop. By the letter dated 3/1/2011, comma, it was informed to the petitioner that the competent authority in reference to the contract agreement, comma, had approved the final variation statement. In reference to had approved the final variation statement against the contract agreement number so and so dated 27/2/2007. And the petitioner was thereby requested to deposit a sum of rupees 25,21,881.21 as vitiated amount, or to submit a no claim certificate for deduction of the said sum from the final billed amount of the petitioner which would result in finalization of the contract agreement from the end of the respondent NF Railway authorities. Full stop. Then which one?
Page number 111, my lord. It was written by Deputy Chief Engineer to the Chief Engineer.
The letter bearing number 111. Dated 5/1/2011. Was from Deputy Chief Engineer, Construction 2, NF Railway, to the Chief Engineer, Construction 3, NF Railway. Containing a proposal to consider the contract work as a case of single tender and to single tender so as to give effect to the contract agreement as a vitiated one followed by an act of recovery of a sum of rupees 25 lakh 21,881.27 as the vitiated amount
My lord,
for against the contract agreement number so and so dated 27/2/2007,
my lord, my lord.
right?
I'm just sorry, your lordship is dictating. The lordship has said so that it can be given effect to be a vitiated amount. It is just opposite, so that it may not be given effect to a vitiated amount. So that it can be treated as a single tender, so that the vitiated amount, it may not be given the effect of a vitiated contract. The lordship has said so that it can be given the effect of a vitiated contract, actually so that it cannot be given the effect of a vitiated contract. Because if there is a single contract, if it is considered as a single tender, there will not be any other tenderer with whom the rate can be compared. That is precisely what is there at page number 114.
Okay.
Roman four.
Letter addressed to the so and so. Which is containing a proposal. To consider the contract agreement for single tender on the following grounds. Page 113, I think that is the one. Page 113,
Yes, 113, and precise point is at page number 114, Roman 4.
he has explained the situation.
Yes, yes, yes.
He has explained the situation.
Absolutely.
Oh, yes, mentioned there what are the power delegated, that railway board circular note. This is extracted from somewhere.
Roman 4. is not vitiated.
Suppose it is vitiated, what would happen?
They could, that is my lord, assuming that this vitiation clause is there in the tender for a while. Even then, they cannot deduct this for this tender because there is a variation is beyond 25%. When it is beyond 25%,
Oh, why we are going into that aspect? It is when it is not there. Why we should go into that aspect?
No,
Stating that. The final variation amount decreased beyond within bracket minus sign. 113 আছে explicit 25% from the original contract value of rupees 18 crore 74,69,000. It further mentioned that as per the SOP 21.20, as per the provisions contained in (21.20) of the SOP -2009, the contract agreement had to be treated as single tender with final concurrence, if the amount had decreased beyond within bracket minus 25%. No, he is asking for single tender to treat it. Why you are making different submit?
no, my lord. My lord, it's my problem not being able to communicate what I. If
No,
it
he
is
is asking for treating it as a single
single
tender.
tender, and therefore it should not be vitiated. That is exactly what they're saying in page 4, para 4.
I am not understanding it. Fair. I have heard Mr. M. Biswas, learned counsel for the petitioner, and Mr. P.K. Das, learned CGC or Railway
Madam, additional standing also, madam.
additional standing
Yes.
counsel. NF Railway
Right.
for all the respondents.
Madam.
Mr. Biswas, learned counsel for the petition has submitted that it is not in dispute that the petitioner had executed the contract work to the extent of 100%, as certified by the NF Railway authorities in the certificate dated 29/7/2009. Full stop. Where is the variation part? Variation part.
Variation part, your lordship will find at page number 103, and the variation statement is 104.
Clause.
Oh, variation of vitiation. Clause
Not
53,
vitiation, Mr. Not vitiation, variation.
variation. Variation clause, my lord.
It will be definitely before vitiation. That day I have seen. Today, I didn't know.
Variation, there is a clause.
Ah, yes. There is a clause.
Yes,
No, no, yes, it is said.
both are.
Deviation. General.
Ah, yes, page number 41,
41, madam. 2.8.
2.8.
He has drawn attention to clause number 2.8 of the additional special conditions of contract. Within bracket, additional assist. To submit that, the parties to the contract agreement had agreed that the quantities specified in the schedule of work were approximate and to give and meant to give the tenderers an idea of the quantum of works involved. Full stop. And the full stop, liberty stood reserved to the respondent railway authorities rights to reserve to increase or decrease the quantities against various items and stroke or delete from the item up to 50% of the quantities or even more, page 41, 2.8. As per the actual requirement as cited. Thus, there was provision for reduced payment. After measurements of the completed work with the issuance of a final variation statement. First off, the petitioner is not aggrieved to that part of the final variation statement issued on 8/12/2010, whereby the revised the value of the contract work had been revised to rupees 12,86,54,574.39. Full stop. The petitioner is aggrieved by that part of the final variation statement dated 8/12/2012 and whereby a sum of rupees 25,21,881.27 was sought to be recovered on the premise that the contract agreement vitiated to that extent. Contending that such kind of recovery on the ground of vitiation was not contemplated in the contract agreement. Full stop. He has strenuously contended that though in clause 6.1 of the additional SCC, a mention was made about quote unquote vitiation, comma, the concept of vitiation has neither been explained in the contract agreement nor the same was brought to the notice of the petitioner for any kind of consent from his part by any mode whatsoever. Full stop. In such view of the matter, comma, it was absolutely arbitrary on the part of the respondent authorities to ask for a no-claim certificate from the petitioner while letter 110 dated 3/1/2011 for the purpose of deducting the sum of rupees 25,21,881.21 as vitiated amount from the final bill amount of the petition for the contract work. Full stop. Mr. Biswas has further submitted that though the letter dated 5/1/2011 was not addressed, was a interdepartmental communication between authorities in the NF Railway, but a perusal of the same would go to show that a decision had been taken by the respondent NF Railway authorities, comma, as revealed from the, as already revealed from the letter dated 3/1/2011, comma, to affect a recovery of a sum of rupees 25,000 so and so, either from the final bill amount of the petitioner or on the basis of a no claim certificate. Yes. It is further contended that though in a letter number is 115 dated 5/5/1995 of the Railway Board, comma, Ministry of Railway, Government of India, the NF Railway authorities The aspect of vitiation was brought for the purpose of consideration in contracts executed by the railway authorities. Comma. The said letter was never made a part of the contract agreement number so and so dated so and so by making a mention of it therein. Full stop. It is his contention that to bind a contractor like the petitioner in the manner contemplated in the circular in a letter dated 5/5/1995 of the Railway Board, comma, it was incumbent on the part of the NF Railway authorities to specifically include the same in the contract agreement by mentioning it. In the absence of any explanation provided in the contract agreement, and since the letter dated 1995 was not part of the contract agreement, comma, it is not open for the respondent railway authorities to stick to take a resort to a method which was not part of the contract agreement dated in response, comma, Mr. Das learned additional railway council,
Malo, standing council for railway, Malo.
additional standing council. NF Railway. Which you sought to rely on 1995?
From the affidavit, para 13, 14 and 18, my lord. And moreover, my lord, that as per 117, my lord, that last line, in case of vitiation of a tender, sanction of competent authority as per single tender should be obtained. My lord, as per on receipt of the proposal, my lord, that was my lord, deliberated by the competent authority, and that was rejected, my lord, in my affidavit, page 9, 19/1/2012, my lord. The competent authority has rejected. We have communicated to him.
What
So for,
rejected?
so for that,
Rejection means what?
my lord,
I do not understand your languages, so please explain me.
sorry,
Rejection mean what?
my lord, in
Allowed?
No,
What?
my lord. So for to treat the particular tender, my lord, as a single tender, my lord, that the proposal was given by the my lord, engineer. That proposal was, my lord, has to be, my lord, have a sanction from the competent authority as per 5/5/1995, 117 page last line, my lord. And that proposal, while this proposal came to, my lord, the competent authority,
page 9 of my affidavit, my lord. That treating to be the single tender, that proposal was rejected, my lord. So 19/1/2012, my lord.
Hmm.
So these are my submission, my lord.
No, so what would happen if it is rejected?
My lord, then my lord, will be entitled to recover that, my lord, 25 lakhs, my lord, from the vitiated amount.
I am not understanding any of from your side, this side also that side. I think both are diametrically opposite submission. Is it not? He is
I could, see.
this last document,
Yes.
page 5/1/2011, page
Yes.
111.
Yes.
Right.
Yes.
He is writing something that it is recommended this contract may please be considered for single tender.
Yes.
If single tender is considered, then there will be no recovery or what?
No recovery. Because
And
there will
my lord-
not be a rival tenderer with whom the rate can be compared.
My lord, that
So therefore,
recommendation
what
was
I-
not accepted, my lord, because that sanction from the competent authority required. In our affidavit, we have
And
stated.
why you are challenging this?
He has to
Never
challenge
challenged.
19/1, my
I
lord.
have never challenged this. I am relying this in my support. That their own documents say that it should be treated as a single tender.
No, that has been already rejected.
Impugn letter 5/1/2011.
No, why not?
My lord,
Page
here, my lord,
19.
19/1. He has not challenged that.
No. That 19 one is different. Page 19 in your prayer.
Yes, page 19 in my prayer, my lord.
I understand that impugn means challenged.
Yes, my lord.
Okay?
Yes.
So this is with my limited understanding.
No, my lord.
So this impugn is 5/1/2011 also,
Yes.
which contained a recommendation. Please treat this as a single tender.
That cannot be challenged.
My lord, yes, my lord. I have challenged it because of page 112. Because 112 contained this formula of vitiation here. So I'll have to challenge it.
Okay. Right, this is sort of line. I'll give you. The main reason Mr. Vishwas has submitted that the main reason to challenge the letter dated 5/1/2011, comma, is that the respondent railway authorities had brought in the figures of another contractor within bracket L2
Yes.
to compare, to make a comparison of the rates in respect of 5 number of items offered by the petitioner in his bid to arrive at the alleged vitiated amount of rupees
Absolutely.
25,71,881.27. Full stop. According to him, comma, when neither at a time of execution of a contract agreement nor the parties had agreed for the method of calculation in such a manner at a later point of time by any kind of supplementary agreement, comma, the petitioner as the contractor cannot be asked to agree to such method. That's all. In response. Mr. Das, additional standing counsel, NF Railway, has placed has at first placed reliance on clause 6.0 is 53 vitiation of contract. Colon দিতে, right? To contend that if during the execution of the contract for variation of quantities against items of work became inevitable and such variation caused vitiation of the contract, it is permissible on the part of the NF Railway authorities as the tendering authority to deduct the amount of vitiation from the contractor's bill. Full stop. While admitting that the concept of the vitiation has not been defined in the contract agreement or any other documents like so and so, which were made part of the contract agreement. He has referred to the letter dated 5/5/1995 of the Railway Board. Full stop. He has contended that the concept of vitiation was
Paraformal.
explained in the said letter dated 5/5/1995 and full stop. It was made clear therein that the concept of vitiation gets operational in the event, there is increase or decrease of quantities
Price will be L1.
substantially that is more than 25% of the overall accepted tender cost, right?
And my para 18 of the malot affidavit malot. Para 18 malot.
This part is correct or not?
Malot, so far the vitiation is what I understand malot. We have to malot, this is a rate was contract, so therefore item was rate. In all situation, L1 should be L1. Malot, we,
I'll go to that.
yes, para 18 malot. The para
I'll
18.
go to that
Yes.
where I have not traveled.
Sorry,
Whether what I dictated correct or not.
that's correct. Malot, yes, malot.
I'll withdraw then your submission. If it is not,
Para 18 malot, that may be additional malot. Yes.
I'll go to
That
that.
is correct.
I'll go to that. But question is, what I dictated was correct or not correct?
Why not? It is absolutely correct, malot.
It is his contention that the petitioner as the tenderer stroke contractor had full knowledge of the implication of clause 6.0 of the additional SCC. Full stop. Yes, which part of affidavit?
Paragraph 18, my lord, that
18 only.
18 only, what I have, my lord, vitiation.
Okay.
Vitiation, so for vitiation. And my lord, this is a rare case, my lord. In this particular dispute was adjudicated before the, my lord, adjudication Madras High Court, my lord. My lord, before the Madras High Court, that meaning of which, my lord, vitiation, they have given, my lord. If lordship permit,
No,
one
making
paragraph.
of ignition may be given there,
Yes, yes.
but have you given to the contractor or not? That
So
is the
far-
question.
So,
That is why I have given enough opportunity on the earlier date also,
yes, yes.
that please tell me what is the concept of vitiation and whether this man had the knowledge or not.
So for our understanding, my lord, para 18 is the vitiation, my lord.
So it is a clear case of
MS Gill,
Govardhan Bhaji and
also MS Gill,
MS Gill.
MS Gill.
Cannot be substituted.
He has relied on the statement made in paragraph 18 of the affidavit in opposition filed by the respondents. Wherein it is sought to contend that the respondent railway authorities, while accepting an offer, considers the overall bidwill of the bidders and not the rates of individual items. Full stop. It is sought to contend that the lowest, eligible and technically suitable tenderer within bracket L1 is awarded the work. Full stop. It has envisaged a situation that respondent NF railway authorities have envisaged a situation that it is quite possible that for some of the items, the rates quoted by L1 might be higher. Running page 123, paragraph 18 to us. Though overall, he is L1. And so it is also quite possible for some items in which L1 is not the lowest, there is a positive variation in quantities. And for other items in which L1 is the lowest, there is a negative variation in quantities. Full stop. It is in such situation, vitiation can set in, and then L1 may not remain L1. Full stop. It is there. It is for the purpose of ensuring that L1 remains L1 at all times. The vitiation amount has to be deducted from the contractor as per clause 6.0 of the additional SCC. That is your story.
That's the story.
So whenever you want, you can do anything. Okay. I have given due consideration to the rival submissions made by the learned counsel for the parties and have also gone through the materials brought on record by the parties through their pleadings. Somewhere else I'll get this.
It is CAB, my lord.
Not CAB. I'll dictate. You rely on this one. Mr. Das, you'll rely on this one.
And this is-
2018?
This is subsequent to this particular contract, my lord.
Ah,
So I cannot. Oblige, my lord. Patience hearing and.
Lordship, item.
no, I have to understand.
My lord, it is.
I have to
actually, my lord,
understand the
alien-
concept.
alien- It's a kind of alien subject. my
I have come across this appreciation for the first time.
lord. Yes, my lord.
Initially, when because I filed it so many years
নাম
back.
কেইটা লিখি দিব হাৰ্ডিং পাৰ্ট ডেটা পাৰিলে কোনটো ডেটা দিব পাৰিব বহুত দেৰি হ'ব না Next question. As a hearing remain inconclusive, this is the case again 21-9 as part heard.
12 also.
Part heard. The other, I have not heard. I don't know any item 11. You remain there, we'll see. We'll continue from
On the end of his.
after
In
ending
fact,
this.
item 11, I may not also argue more financial or contagion. I'm not being.
Okay. দুইটা কেস লিখে দিব মানে এইটো আইটেম নাম্বার 12 হ্যাঁ so the sorry the sorry the arguments sorry no
Item number.
the hearing of the learned counsel for the parties could not be for the parties in item 12 13 is not completed and has have remained conclusive towards a partner. A partner as the other petition
Item 12.
WPC number so and so is tagged with WPC number so and so. The said petition be also listed on. So
Item number 16, my lord.
not today. I have some meeting.
It is urgent, my lord. Time does get filling annual. So let it be fixed on next 5 days. Is it related? Next 5 days, 7th of September.
None. 7th of September, not possible to
Then
I'll not be there.
some other date,
I'll not be there, my lord.
some other date. This is 2017.
Make it
We are giving more priority to 2012, 13, 2006 also,
But it related to pensionary benefit of the petitioner.
whatever,
It's a matter of conviction.
Make it a 19.
whatever, 2017,
don't
some
think, and
2008, likely it later did you. Even a partner could not be fixed prior to 21-9.
Make it 19, my lord.
Did you?
19
21,
September.
21.
21.
K. Sharma. As for by Mr. K. Sharma and counsel for the part petitioner and as agreed to by Mr. H. K. Das.
my lord.
Standing counsel DHC